Hey everyone, I'm Kent Tran and welcome to my American Politics Masterclass. I want to thank you for watching my American Politics Masterclass. I'm excited to teach you everything that I've learned about American politics. I've spent my entire life reading, learning, and understanding American politics. Now, I'm ready and prepared to teach you everything that I know so that you can have the knowledge and understanding of American politics and understand how American politics functions within our government and our society. I'm excited to teach you everything that I've learned, and I'm ready to give you my all in this American Politics Masterclass. So, with that being said, let's get this masterclass started. Under the U.S. Constitution, there are 7 articles of the U.S. Constitution. For the purpose of this masterclass, I want to focus my attention on the first 3 articles of the U.S. Constitution and discuss and explain the importance of the first 3 articles of the U.S. Constitution. Under Article 1 of the U.S. Constitution, Article 1 establishes the legislative branch. Legislative branch is the United States Congress. The United States Congress is a bicameral legislature, meaning there are 2 houses of Congress, the U.S. House of Representatives and the U.S. Senate. There are 435 representatives in the U.S. House of Representatives and 100 senators in the U.S. Senate. Under Article 2 of the U.S. Constitution, Article 2 establishes the executive branch of government. The executive branch of government is the United States President. The United States presidency is a unitary executive, meaning there is one president of the United States of America who leads the executive branch of government. Under Article 3 of the U.S. Constitution, Article 3 establishes the judicial branch of government. The judicial branch of government is the United States Supreme Court. The inferior courts under the United States Supreme Court were created by Congress through federal law or federal statute. Under the U.S. Supreme Court, there are 13 U.S. Court of Appeals spread throughout the jurisdiction of the United States of America. Under the 13 U.S. Court of Appeals, there are 94 U.S. District Courts spread throughout the jurisdiction of the United States of America. The judicial branch of government and the federal courts act as an independent judiciary, meaning the federal courts are independent of Congress and the President of the United States. So those are the first 3 articles of the U.S. Constitution, and I will discuss later the importance of each branch of government, and I will discuss and explain the duties and the roles of Congress, the President of the United States, and the U.S. Supreme Court. Now, I want to discuss and explain with you separation of powers of each branch of government. Each branch of government was given specific powers and duties to that branch of government. Power must be balanced by power in order to avoid tyranny by the other branch of government. The principle of separation of powers is not explicitly stated in the U.S. Constitution. However, it is interpreted by the specific duties of each branch of government. The 3 branches of government are separate and co-equal branches of government. The entire structure of the national government is built upon the legislative branch, executive branch, and judicial branch. Now, I want to explain with you how Congress functions as a political institution. Congress was intended to be the most powerful branch of government because the vast amount of duties it possesses under Article 1, Section 8 of the U.S. Constitution. In Congress, there's the U.S. House of Representatives and the U.S. Senate. Representatives and senators' main responsibility is to their congressional district or state that they represent and to their constituency. Representatives represent a congressional district which has a tendency to have a concentration of a homogeneous constituency, while senators represent an entire state which has a tendency to represent a more heterogeneous constituency. Both the House of Representatives and senators serve a different constituency, and their constituency have different needs for the representatives or senators. Because each constituency has different interests, members of Congress have different interests. Members of Congress comes from different walks of life, and they represent different types of constituency in each congressional district or entire state they represent throughout the United States of America. Each member of Congress in the U.S. House of Representatives and the U.S. Senate want to pursue certain legislation, vote a certain way on bills, and pursue pork barrel legislation that benefits their congressional district or state so that they can secure re-election in Congress. So because of this diverse set of members of Congress with diverse constituency that they represent, each member of Congress has a different set of interests in Congress. There are three main interests in Congress that motivates their actions and behaviors in Congress. First, to secure re-election to another term in Congress in congressional elections. Second, to pursue legislation and policies that are effective policies. And third, to represent their constituency's interests and views on bills and issues in Congress. Those three main interests are the three main interests that motivates the actions and behaviors of Congress whenever they act in Congress, whether it be on the floor of Congress in the U.S. House of Representatives or the U.S. Senate. Whenever a member of Congress gives a speech on the floor of Congress in the House of Representatives or the Senate, when they express their opinions and vote on bills or issues in standing committees and subcommittees in Congress, in the House of Representatives and the U.S. Senate, and whenever they vote on bills on the floor of the House of Representatives and the U.S. Senate, and even when they vote on impeachment in the U.S. House of Representatives and the impeachment trial in the U.S. Senate. The first interest. Members of Congress want to secure re-election to another term in Congress so that they continue to stay in power and pursue policies and legislation that represents their constituencies on bills and issues. Members of Congress seek to gain another term and secure re-election in Congress so that they can secure power in Congress and seniority within Congress and pursue legislation so that they can continue to advance their policy agenda and interests in Congress. If members of Congress do not get re-elected to another term in Congress, then their power as an elected official is over and they cannot pursue any legislation in Congress that represents their policy agenda for their constituency in Congress. Re-election serves as a means of job security so that members of Congress can continue to stay in power and pursue legislation and policies that represents their interests. The second interest. Members of Congress want to pursue bills, policies, and legislation that are effective policies in Congress because that helps build their track record in Congress and helps build their professional reputation in Congress. When members of Congress pursue strong, effective policies, that helps build their track record with other members of Congress and with their constituency. And their constituency can view their elected official in Congress, in the House of Representatives and the Senate, as an elected official who has a strong track record of pursuing effective policies that represents that elected official's policy interests and views on various legislation, bills, and policies in Congress. Members of Congress pursue those effective policies to build their track record, and when they build a track record of standing for something strong in Congress, that helps them with their re-election in Congress to another term in Congress during congressional elections. So the second interest of Congress is to pursue legislation, bills, and policies that are effective policies because that helps build their track record of standing for something that they believe in. And that helps build their confidence where the constituency and their fellow members of Congress views that elected official as an effective legislature and member of Congress who has a strong track record of pursuing effective policies. And the third interest, members of Congress want to best represent their constituency's interests on bills, issues in Congress. Whenever members of Congress act, speak, and vote in Congress, they do so to best represent their constituency's interests and views on those bills and issues that they vote on in Congress. Members of Congress seek to best represent their constituent interests because they want to view themselves as representative of the people they represent in their constituency, either in the congressional district or the state that they represent. When members of Congress act as their constituency's voice, they act upon their people's behalf. Members of Congress want to act as the voice of their constituency back home. When they vote on bills and issues and give speeches in Congress, they best want to represent the perspective of how their constituency would view those bills and issues in Congress and act as the voice of the people they represent back home. When members of Congress represent their constituency's views and interests on bills and issues in Congress, that can help them look as though they're effective policymakers and elected officials in Congress. And that in turn can help them with their re-election to another term in Congress when congressional election comes around in Congress, either in the House of Representatives or the US Senate. So that is a third interest that motivates the behaviors of Congress. Members of Congress want to represent their constituency's views and interests on bills and issues they pursue in Congress. Now, I want to discuss and explain the presidency of the United States within the US Constitution. The presidency of the United States is established in Article 2, Section 1 of the US Constitution. Article 2 of the US Constitution starts out by saying, "The executive power shall be vested in the President of the United States of America." That means the President of the United States of America is the head of the executive branch of government. Article 2, Section 1 states that the President is required to preserve, protect, and defend the Constitution of the United States of America. The role of the presidency is to faithfully enforce all federal laws passed by Congress onto the federal government, state government, and the American people. The President of the United States is also the head of state, which means the President of the United States is entitled to special deference and respect as the President of the United States. The President of the United States is the head of government, meaning he is the highest government official within the government of the United States of America. The President of the United States is a very special role within the US Constitution because it is one person who is the head of an entire branch of government, the executive branch of government. Under the US Constitution, Article 2 of the US Constitution, the President of the United States has three types of powers: implied powers, delegated powers, and expressed powers. Now, I want to discuss and explain with you presidential power and how the President of the United States exercises presidential power. There are two main interpretations of how the President of the United States exercises presidential power. The first is through executive administration of the presidency, and second is through the President's ability to persuade Congress and the American people to pursue and adopt the President's policy agenda. First, I want to explain executive administration. The President of the United States can use his executive administration as the head of the executive branch of government to lead the executive branch of government by writing statements like executive orders and signing statements to enforce the government agencies within the executive branch of government to pursue a specific action or a specific course of action based upon the President's written executive orders. Executive orders have been used by the President of the United States throughout American history so that the executive branch of government and the government agencies within the executive branch of government can take specific actions as ordered by the President of the United States and signed by the President of the United States through executive orders that does not require consent or knowledge from Congress. Executive orders have been used like to free the slaves from the Confederate South in 1865 through the Emancipation Proclamation. It has been used to desegregate U.S. military between whites and blacks so that white and black soldiers can fight along with each other in the same combat unit. Executive orders have been used to order Japanese Americans into internment camps after the attacks on Pearl Harbor. Executive orders have been used to create the EPA, Environmental Protection Agency, after the Clean Air Act was signed into law by the President of the United States. Executive orders have been used to ban foreigners from the Middle East from entering the United States of America as foreigners. Executive orders have been used to order U.S. Army paratroopers, U.S. Army soldiers to Central High School in Little Rock, Arkansas, to publicly enforce desegregation of our public schools. All those examples of executive orders have been used by the President of the United States so that the government agencies within the executive branch of government can take specific actions as ordered by the President of the United States through his written executive orders. Executive orders have also been used to allow children of illegal immigrants to stay in America and continue their education under DACA. So those are all examples of how executive orders have been used by the President of the United States throughout American history to order government agencies to take a specific action as ordered by the President of the United States. Signing statements are signed by the President of the United States during or after the President of the United States signs a bill into law. And the signing statement basically states that the President of the United States can refuse to enforce a specific law that he passed into law because the President of the United States disagrees with the constitutionality of that federal law and interprets it differently for what that written law states, or the President of the United States believes that written law is unconstitutional and writes a signing statement of how he wants the government agencies within the executive branch to enforce a specific law when he disagrees with that specific law that is passed into law. So the President of the United States uses his executive administrations like executive orders and signing statements as the head of the executive branch of government to enforce the government agencies within the executive branch of government to take a specific action as ordered by the President of the United States. The second form of presidential power is the ability of the President to persuade Congress and the American people to pursue the President's policy agenda. The President of the United States uses presidential power by persuading other people to adopt the President's policy agenda. The President of the United States addresses Congress through the State of the Union address, joint session of Congress, or through private meetings in the White House with the President of the United States and members of Congress. The President of the United States gives reasoned arguments to members of Congress as to why Congress should pursue the President's policy agenda. The President makes his case and makes his reasoned arguments as to why Congress should pursue the President's policy agenda based upon the current events that occur in Washington, D.C. and throughout America. The President gives his policy proposals to Congress, and then Congress receives that policy proposal. Then it is up to Congress to pursue legislation in Congress that reflects the President's policy agenda. And depending upon whether members of Congress are persuaded by the President's policy agenda, can determine whether Congress can act upon the President's policy proposal and enact legislation in Congress that reflects the President's policy preferences on the issues. So that is how the President of the United States exercises persuasion through Congress. The President of the United States gives his reasoned arguments to Congress, and then Congress acts upon the President's policy proposals. And depending upon whether members of Congress are persuaded by the President's policy agenda, can determine whether Congress can enact and pass legislation in Congress that reflects the President's policy agenda through Congress. The President of the United States is the head of the executive branch of government. The President of the United States has a duty to set the legislative agenda to Congress and set his policy agenda through Congress from the State of the Union address or joint session of Congress. The President communicates his policy agenda to Congress and gives his reasoned arguments as to why Congress should pursue the President's policy agenda. The President of the United States pursues his policy agenda by making reasoned arguments and using his charm to persuade Congress to pursue the President's policy agenda. The President of the United States and Congress are separate institutions that share power with one another. Congress creates the law and the President enforces the law. The President of the United States can only pass legislation through Congress by persuading members of Congress to act upon the President's policy agenda. And if members of Congress are persuaded by the President's policy agenda, Congress can act upon the President's policy agenda and pass legislation that reflects the President's policy preferences on the issues. Then the President of the United States signs that bill into law. And once it becomes a law of the land, then the President of the United States enforces that law upon the federal government, state government, and the American people. For the first 200 years of the American presidency, the President of the United States was interpreted to be merely a clerk, where the President of the United States simply enforces the laws passed by Congress. But from the 20th century until now, the President of the United States is seen as the country's leader, where Congress and the American people look to the President to set the policy agenda for Congress to pursue. And the President uses his reasoned arguments and charm to communicate his policy agenda to Congress at the State of the Union address, joint session of Congress, so that members of Congress can act upon the President's policy agenda. And the President makes his reasoned arguments as to why Congress should pursue the President's policy agenda. So this is the President's authority and how he exercises power through the power of persuasion to Congress and through the American people. Now, I want to discuss and explain with you the Supreme Court of the United States. The Supreme Court of the United States is the only federal court established by Article 3 under the U.S. Constitution. Article 3 under the U.S. Constitution starts out by stating, "The Supreme Court shall be vested in a Supreme Court of the United States." The inferior courts were created by Congress through federal law or federal statute. According to Chief Justice John Roberts, the role of the Supreme Court of the United States is to make all federal laws uniform in the country. Two opposing parties come before the U.S. Supreme Court asking the Supreme Court of the United States to determine the constitutionality of a federal law passed by Congress. The justices on the U.S. Supreme Court must determine whether a federal law passed by Congress is constitutional or unconstitutional based upon the written text of the U.S. Constitution. And the Supreme Court of the United States determines who to side with before a federal case that comes before the U.S. Supreme Court. And they use the text of the U.S. Constitution to determine who to side with on a case that comes before the U.S. Supreme Court, the petitioner or the respondent. That is the role of the Supreme Court of the United States. Now, I want to discuss and explain how the Supreme Court of the United States takes a case through writ of certiorari. Most cases that come before the Supreme Court of the United States go through a writ of certiorari. Certiorari is Latin for to make more certain. When an individual loses in lower federal courts or state courts and wants the Supreme Court of the United States to take his or her case, the individual has 90 days to file a writ of certiorari with the Supreme Court of the United States, asking the Supreme Court of the United States to consider taking on that individual's case. When an individual files for a writ of certiorari, the clerk of the U.S. Supreme Court reviews all the writs of certiorari that are granted to the U.S. Supreme Court. The U.S. Supreme Court receives a list of thousands of cases that go through the writ of certiorari. And the clerk of the U.S. Supreme Court reviews the certiorari pool of all the cases asking the U.S. Supreme Court to hear that case. The clerk of the U.S. Supreme Court reviews every single case and writes a memo to the justices on the U.S. Supreme Court. And most justices have participated in the certiorari pool, where the justices and the law clerks participate in the certiorari pool, and the law clerks summarize the facts and the issues of each case and gives them to all the justices so that the justices, all 9 of them, can review the facts and the issues of the case. Any individual on the U.S. Supreme Court, there are 9 justices on the U.S. Supreme Court, any Supreme Court justice who reviews and participates in the certiorari poll can put a case on the discuss list so that the justices can further consider whether they should consider that case by the U.S. Supreme Court. And any of those justices can put any case on the discuss list. If a Supreme Court justice does not put a case on the discuss list, then it is automatically denied certiorari. So when a justice on the U.S. Supreme Court puts a case on the discuss list so that the justices can further consider that case, later, when all 9 justices participate in the certiorari poll, during the justices' closed conferences, all 9 of them can consider discussing those cases on the discuss list and vote on those cases on the discuss list and whether the Supreme Court of the United States will hear that case before the U.S. Supreme Court. And the justices on the U.S. Supreme Court discuss and evaluate and vote on those cases on the discuss list during the Supreme Court's closed-door conferences. Certiorari is granted when 4 justices or more on the U.S. Supreme Court agree to hear a case before the U.S. Supreme Court. Certiorari is granted when 4 justices or more agree that that pending case satisfies Rule 10 of the U.S. Supreme Court rules. Rule 10 of the U.S. Supreme Court rules states that certiorari is granted when there are special and compelling circumstances that requires the U.S. Supreme Court to hear that case before the U.S. Supreme Court. Any one of the reasons can include a case that comes before the U.S. Supreme Court where there 2 lower circuit courts have conflicting opinions and requires the U.S. Supreme Court to settle that case. Another reason could be a conflicting decision between a state court and a federal circuit court, and the U.S. Supreme Court has to rule the finality and constitutionality of federal law. Another reason is because there are 2 state courts that have conflicting decisions, and the U.S. Supreme Court has to take on that case to determine who to side with, the petitioner or the respondent. Or it could be cases that involve the civil liberties of the American people under the first 10 amendments, the U.S. Bill of Rights, under the U.S. Constitution. And another reason could be where the federal government is an appellant on that case. So any of those compelling and special circumstances under Rule 10 of the U.S. Supreme Court can require the U.S. Supreme Court to hear that case. And 4 justices or more on the U.S. Supreme Court must be satisfied and persuaded that that case satisfies Rule 10 of the U.S. Supreme Court rules. And certiorari is granted when 4 justices or more on the U.S. Supreme Court agree to hear that case before the U.S. Supreme Court so that the U.S. Supreme Court can decide the outcome of that case. So that is the process of writ of certiorari. Now, I want to discuss and explain with you the Supreme Court procedures on how cases come before the U.S. Supreme Court. When a case comes before the U.S. Supreme Court, lawyers must prepare a legal brief to the U.S. Supreme Court, where lawyers for each party, the petitioner and respondent, create legal briefs to the U.S. Supreme Court, and they make their legal case as to why the Supreme Court should rule in their party's favor. Lawyers use case precedent, prior cases the Supreme Court has ruled in the past with similar facts and issues at hand to make the legal argument as to why the court should rule in their party's favor based upon the case precedents and the court's decisions that they've made in the past with similar facts and issues at hand. The lawyers can also use case precedent to show how lower courts have ruled in their party's favor with similar facts and issues at hand, and how the lower courts have ruled on decisions relevant to the pending case at hand at the U.S. Supreme Court. Lawyers can also receive help from interest groups who can also write legal briefs on their party's behalf to the U.S. Supreme Court. Interest groups who want to help one party or the other party litigant before a case before the U.S. Supreme Court can file an amicus curiae brief, where interest groups, lawyers who work for those interest groups, can write those legal documents, legal briefs, as to why the court should rule in their party's favor as well, to assist the lawyers, the petitioner and the respondent, when they create legal briefs before the U.S. Supreme Court. At times when cases come before the U.S. Supreme Court, many interest groups can file many amicus curiae briefs to the U.S. Supreme Court on behalf of one party litigant or the other, the petitioner or the respondent, to make their legal argument because they have an interest in their party's litigant's favor, and they will have interest in their party litigant to make sure that their party wins their case before the U.S. Supreme Court. So that is how lawyers prepare for a case that comes before the U.S. Supreme Court. They write legal briefs and use case precedents and show how the court has ruled on previous cases with similar facts and issues at hand to make the legal argument as to why the U.S. Supreme Court should rule in their party's favor. Then the lawyers for each side, the petitioner and the respondent, meet at the Supreme Court of the United States in Washington, D.C., where the lawyers for the petitioner and the respondent make their oral arguments before the justices on the U.S. Supreme Court. During oral arguments, the lawyers for the petitioners and the respondents make their legal arguments, and they argue their case as to why the justices should rule in their party's favor. They use case precedents to make their oral arguments and how the Supreme Court has ruled in previous case precedents on the pending case, and why the U.S. Supreme Court should rule in their party's favor based upon the case precedents the court has ruled in the past with similar facts issues at hand. Oral arguments allow justices to ask lawyers questions that were not raised by the opposing side's briefs, and to ask them questions in order so that they could better understand the issue at hand for each lawyer, the petitioner and the respondent. Justices can also ask questions beyond the legal issue at hand in the case and ask questions about the implications of that case for the Supreme Court and the nation as well. So when the lawyers appear before the Supreme Court, the lawyers that represent the petitioner and the respondent make their oral arguments. The petitioner makes his or her oral argument first before the Supreme Court for 30 minutes, while the justices ask questions to the lawyer's petitioner for 30 minutes. Then the respondent makes his or her oral arguments for 30 minutes and answers questions from the justices about his or her legal arguments during the oral arguments for 30 minutes. Then once the petitioner speaks for 30 minutes, the respondent speaks for 30 minutes, then Chief Justice John Roberts can allow for rebuttal if he chooses so, to allow each side to respond to the opposing side, if Chief Justice John Roberts allows so. So the lawyer for the petitioner speaks for 30 minutes, and the lawyer for the respondent speaks for 30 minutes, and the Chief Justice John Roberts can allow for rebuttal for each side as well. So that is how the process of the oral argument takes place before the Supreme Court of the United States. After the oral arguments are over, the justices have a closed conference behind closed doors. The 9 justices meet at closed conference in a private room together. And then the 9 justices are seated in order of seniority. And Chief Justice John Roberts speaks first about the case. When Chief Justice John Roberts speaks first about the case, he speaks about the legal issue at hand and what is the issue the Supreme Court must decide, and how should the Supreme Court rule on that pending case. When Chief Justice John Roberts speaks, he cannot be interrupted by another justice. One justice speaks, Chief Justice John Roberts speaks first, then it goes by order of seniority on the Supreme Court. So after Chief Justice John Roberts speaks first about the legal issue at hand and the arguments that he wants to make on that case, then Justice Clarence Thomas speaks second. Then Samuel Alito speaks third. Then Sonia Sotomayor speaks fourth. Then Elena Kagan speaks fifth. Then Neil Gorsuch speaks sixth. Then Brett Kavanaugh speaks seventh. Then Amy Coney Barrett speaks eighth. And then finally, Ketanji Brown Jackson speaks last as the 9th justice on the Supreme Court of the United States. So each justice, when they walk into the room, they walk in order of seniority, and then they sit in the closed conference table. And then Chief Justice John Roberts speaks first about the legal issue at hand and how he wants to decide on that case and whether he wants to rule in favor or against of a party litigant or not, and what is the legal argument at hand. Then after he's finished speaking about the legal arguments at hand, each justice speaks independently without being interrupted by the other justices on the Supreme Court. And they go by order of seniority from the 1st to the 9th. and they speak one by one. After all the justices have spoken once without being interrupted by the other justices, then the justices among themselves discuss and debate the legal issue at hand, and they make their arguments as to why they should or should rule in the other party's favor, petitioner or the respondent. And they use legal arguments and case precedents to make their argument as to how the U.S. Supreme Court should rule in the party's favor based upon that pending case. And they use their persuasion in order to attempt to persuade their fellow justices to support their cause and their side of the argument. So that is how the justices discuss and debate each other during closed conferences behind closed doors. Chief Justice John Roberts speaks first because he's the Chief Justice, and they speak one by one in order of seniority from first to the ninth place. Then discuss and debate among themselves about the legal issue at hand. Then once they're done discussing about the legal issue at hand for that case, then they vote by majority vote on how they will rule on that pending case based upon the legal issue at hand. And when they vote on the pending case at hand, they vote one by one for an order of seniority as well. Chief Justice John Roberts votes first, while Justice Ketanji Brown Jackson votes last. And so when they vote and how they want to decide on a pending case before the Supreme Court, each justice votes one by one in order of seniority. Chief Justice John Roberts votes first, and then Ketanji Brown Jackson votes last. So that is the order of how they discuss, debate, and vote on the pending case before the Supreme Court behind closed doors in a closed conference in the U.S. Supreme Court. After a majority decision is reached for that pending case, the majority who wins in that party's favor creates a legal argument and creates the majority opinion for the majority party as to why the majority of the justices have ruled in that party's favor. A justice on the Supreme Court is assigned the role to write the majority opinion for the majority party. The Chief Justice can write the majority opinion if he wants to, or he can assign another justice in the majority to write the legal opinion as well. Justices on the majority opinion can also write a concurring opinion. A concurring opinion is when a justice wants to emphasize a different rationale or different point in that case as to why he or she has ruled in favor of the majority party. Concurring opinion is when the justice agrees with the majority on that case, but for a different reason, and wants to emphasize a different rationale or reasoning on that case as to why the justice sided with the majority opinion. So justices write their legal drafts and then circulate it with among the other justices, and then they could write concurring opinions if they want to. And then justices who are on the dissenting side can write a dissenting opinion as to why those justices dissented with the majority on that case. The justices who dissent with the majority gives his or her legal reasons and arguments as to why that justice opposed with the majority, and he or she makes that case as to why he or she opposes the majority, so that that justice can persuade fellow justices in the future on future cases involving similar issues and facts at hand. Once the majority opinions have been written, lawyers and judges from the lower courts can read those majority opinions by the justices on the Supreme Court very carefully to ascertain the intent of the Supreme Court on that case. So when future cases arise with similar issues and facts at hand, lawyers and judges on the lower courts can use the Supreme Court decision's case on that pending case to know how exactly to rule on future cases involving similar issues and facts at hand. That is the importance of the justices' legal opinions in their majority opinions and dissenting opinions on cases that come before the Supreme Court. Those legal justices and majority opinion and dissenting opinions sets the case precedent for future cases involving similar facts and issues at hand, and it affects and influences the legal jurisprudence of how justices rule on cases that come before the U.S. Supreme Court on future cases that have the similar facts and issues at hand. So this is the importance and gravity of the justices' legal opinions on cases that come before the Supreme Court of the United States. The 9 justices on the Supreme Court of the United States are the most important justices in the United States of America. The 9 justices are the ones who will determine the future of our civil liberties under the U.S. Bill of Rights. They determine whether the federal laws passed by Congress are constitutional or unconstitutional. They determine whether the president's actions, like executive orders, are constitutional or unconstitutional. They determine whether the future jurisprudence will be interpreted based upon the 9 justices on the Supreme Court. The justices' ideology and how they think will influence their legal argumentation and legal reasoning and how they formulate legal arguments and reasonings on the cases that come before the U.S. Supreme Court. Their ideology, whether it be conservative, liberal, or moderate, will influence how they formulate legal arguments and legal reasonings on the cases that come before the U.S. Supreme Court and can likely determine the outcome of the cases that come before the U.S. Supreme Court. The 9 justices on the U.S. Supreme Court, Chief Justice John Roberts, Clarence Thomas, Samuel Alito, Neil Gorsuch, Brett Kavanaugh, Sonia Sotomayor, Elena Kagan, Amy Coney Barrett, and Ketanji Brown Jackson. Those 9 justices on the U.S. Supreme Court are the most important justices that make up the Supreme Court of the United States of America. Right now, there are currently 6 justices on the U.S. Supreme Court who have a conservative ideology, while there are 3 justices on the Supreme Court who have a liberal ideology. And right now, the Supreme Court is heavily tilted towards the conservatives in terms of their conservative jurisprudence and how they interpret the law, and how they formulate legal arguments and legal opinions on the cases that come before the U.S. Supreme Court. So those are the 9 justices that make up the U.S. Supreme Court, and those 9 justices will determine the future outcome of cases that come before the United States Supreme Court. That is their importance on the Supreme Court of the United States. Now, I want to discuss and explain with you presidential primary elections. In a presidential primary election, candidates run for president of the United States from their respective political parties' nomination in order to earn enough pledged delegates to be that political party's nominee for president of the United States. We have a 2-party system here in America where being elected president of the United States comes from the Republican Party or the Democratic Party. Candidates seek to earn enough pledged delegates to be their political party's nominee for president of the United States in the primary election by winning state primaries and state caucuses in order to earn enough pledged delegates to be their political party's nominee for president of the United States in the general election. Most states have a state primary election. In the state primary election, voters go to a voting location. They cast their votes privately. Then they submit their votes. Then they go home. Voting in a state primary election is very easy and simple to do. When voters cast their votes, they've already made their decisions beforehand when they enter the voting booth to cast their vote in a state primary election. They cast their vote based upon who they want as their political party's nominee for president of the United States in the general election. They make their decision based upon who is the most viable and winnable candidate for president of the United States, who has the best chance of being elected president of the United States in the general election. That's how voters in the Republican primary election or Democratic primary election within the state governments cast their votes based upon. They base their votes based upon the candidate's viability, credibility, and winnability, be that political party's nominee for president of the United States, so that they can then win the general election. That's how voters cast their votes. They go to a voting location, cast their vote privately, submit their vote privately, then they go home. And they cast their vote based upon which candidate they want as their political party's nominee for president of the United States in the general election. So most states have a primary election, like the California primary election, Texas primary election, Florida primary election, New York primary, Wisconsin primary, Michigan primary, Pennsylvania primary, Massachusetts primary, etc. That's how a state primary conducts its votes in a state primary election. Some other states have a caucus system. A caucus is a non-traditional form of voting in the state government where individuals who participate in the state caucus vote for candidates for president of the United States in a non-traditional form. A caucus is a private business meeting of individuals from their respective political party who vote on party agendas, issues, and candidates for President of the United States. Within those caucus meetings, individuals within a political party make decisions and vote on party issues, agendas, and candidates for President of the United States. A caucus is really a non-traditional form of voting, and it is a little bit complicated from the Democratic caucus versus the Republican caucus. A few states have a caucus like the Iowa caucus and the Nevada caucus. Iowa Democratic Party caucus is different from an Iowa Republican caucus, and I want to discuss the differences between a Democratic caucus and a Republican caucus within the first Iowa caucus. Now, I want to discuss and explain how the Iowa Democratic caucus works. In the Iowa Democratic caucus, voters first gather into a room and register to participate in the Iowa Democratic caucus. Once they register to participate in the Iowa Democratic caucus, they go into a room, usually a large room like a gymnasium, an auditorium, a theater, a church, a living room, or any room that has space to move around. Within that room, there are areas designated for that specific candidate for president within the Democratic Party, like Joe Biden, Elizabeth Warren, Kamala Harris, Pete Buttigieg, Bernie Sanders, etc. And then voters sit or stand within the designated area for the candidate that they wish to caucus for first. Once all the voters have stand or sit in their area for the candidates they want to support, the votes for each candidate are counted in terms of how many voters are supporting each candidate. Once all the votes are counted in the first alignment for each candidate, then in order to be considered a viable candidate, that candidate for President of the United States must have at least 15% of the raw votes within that caucus location site in order to be a viable candidate for President of the United States. If a candidate does not have 15% of the raw vote at that caucus location site or more, then that candidate is not considered viable. And the voters who support a non-viable candidate for President of the United States have a few options. They can go home and not caucus, they can choose to remain uncommitted, or they can caucus with another candidate for President of the United States who is a viable candidate, who has 50% of the raw votes or more within that caucus location site for the Iowa Democratic Caucus location site. Most voters choose to caucus with another candidate for President of the United States who is a viable candidate for President of the United States, who has 50% of the vote or more. So the first alignment determines which candidates are viable candidates, which candidates have 15% or more in order to be a viable candidate. And then the second alignment determines the final vote count at the Iowa caucus location site. After the second alignment is done and over with, then the final vote counts are counted for all the viable candidates and how many voters have supported that candidate for president at the Iowa Democratic Caucus location site. Then once the raw votes are counted at each Iowa Democratic Caucus location site, then the raw votes are sent to the Iowa Democratic Party in Des Moines, Iowa. And then the Iowa Democratic Party awards pledged delegates proportionally based upon how well each candidate does at each district location site of each Iowa caucus location site. So within the state of Iowa, there are many districts. The pledged delegates are awarded proportionally based upon how well the candidates do at each location site, each congressional district within the state of Iowa. So that is how the Iowa Democratic Caucus works and functions. There's the first alignment, which determines which candidate is a viable candidate, which candidate has 50% or more. And then the second alignment determines the final vote count. So that is the complicated process of the Iowa Democratic Caucus. It could take about an hour, 2 hours, maybe 3 hours or so, a few hours, 1 to 2 hours for the vote counts to finish. And so when candidates participate in the first alignment and they want to decide which other candidate they want to pursue based upon the viable candidates in the second alignment, this allows voters to persuade and collect a bargain with their fellow Iowa Democratic voters. So voters can collectively bargain, persuade them by saying, well, if you caucus for my candidate, I'll take you out to lunch or dinner. Or if you go to my candidate, I'll offer you donuts or cookies. Or I'll flip a coin. Heads, I'll go for this candidate. Tails, I vote for that candidate. So in the Iowa Democratic Caucus, voting is done publicly. And voting allows for collective persuasion and collective bargaining amongst the voters within the Iowa Democratic Caucus location site. That is how the Iowa Democratic Caucus functions in the first Iowa caucus. Now, in an Iowa Republican caucus, it is a little bit different than the Iowa Democratic Caucus. In the Iowa Republican Caucus, voters gather into a room and they register to participate and vote in the Iowa Republican Caucus at that location. Once all the voters have gathered in a room, the voters have an individual that represents a specific candidate that they support. Each voter that has a representative that represents that candidate for President of the United States gives a speech to his or her fellow voters within the Iowa Republican Caucus location site. And they give a speech to persuade their fellow Iowa voters why they should vote for their specific candidate for President of the United States and why they should support them and why their candidate should be their political party's nominee for President of the United States. Once each candidate for President of the United States has their representative give a speech in support of their respective candidate for President of the United States, then voters within that room location are given a white piece of paper. And on that white piece of paper, the voters in the Iowa Republican Caucus write down the name of the candidate they will vote for in the Iowa Republican Caucus, whether it be Donald Trump, Nikki Haley, Vivek Ramaswamy, Ron DeSantis, Tim Scott, etc. Once they write down the name of the candidate they wish to vote for in the Iowa Republican Caucus, then they submit their vote privately at the Iowa location site. They turn in their white piece of paper and submit their vote privately. Once all the votes have been submitted, then they are counted at each Iowa Republican Caucus location site. Then the raw votes at each Iowa Republican Caucus are sent to Des Moines, Iowa, to the Iowa Republican Caucus. And then the votes are counted up at each Iowa Republican Caucus location site. And then all the total votes are counted up and the pledged delegates are awarded proportionally based upon how well each candidate does at each Iowa Republican Caucus location site within each district, within each specific area within the state of Iowa. So that is how the Iowa Republican Caucus functions within the Iowa Republican Caucus. In a presidential primary election, the first 4 states are the most important states because the first 4 states establishes a candidate's credibility, viability, and winnability to win a state contest within the first 4 states. So that individual can go on to win their political party's nominee for President of the United States in the primary election, and then go on to the general election to be elected President of the United States in the general election. The first 4 states are Iowa caucus, New Hampshire primary, Nevada caucus, and South Carolina primary. The goal of a candidate for President of the United States is to win first place or second place in any of those 4 state contests: Iowa caucus, New Hampshire primary, Nevada caucus, and South Carolina primary. By winning first or second place in the first 4 states, that establishes a candidate's credibility, viability, and winnability to win a state caucus or state primary, to establish that candidate can win an election within the state government first in the primary election, and then go on to win enough pledged delegates to be that political party's nominee for President of the United States, and then go on to win the general election. That is how important the first 4 states are. It establishes who is viable candidate to be President of the United States and who is not a viable candidate for President of the United States. That's the importance of the first 4 states. And candidates for President of the United States every 4 years realize the importance of the first 4 states in a presidential primary election every 4 years. Now, that wraps up my American Politics Masterclass. I hope you enjoyed my American Politics Masterclass. I gave you my all to teach you the fundamental knowledge of American politics. I hope you learned something from me in American Politics Masterclass. Now, if you liked my American Politics Masterclass, I would ask that you would connect with me on social media. Here is my LinkedIn profile. I have a very nice LinkedIn profile. My LinkedIn profile, it shows everything about me and my life, my work experience, my education, my life experiences. Everything on my LinkedIn profile is honest, truthful, and transparent. It showed where I worked at in the past and for how long I worked for those companies. And it also shows my education. It showed what school I went to for college and graduate school. It showed what degrees I earned in college and graduate school. And I even showed my GPA in college and my GPA in graduate school. And it showed what major I majored in college and grad school as well. And to prove that I went to the schools and earned my degrees, I included copies of my literature review papers, term papers, and essays I wrote for my professors in graduate school. So you could read through them to see what I wrote from my scholarly work as a student of American politics. So you can go through my LinkedIn profile, check it out, and you can connect with me on LinkedIn if you have a LinkedIn profile. This is my Instagram profile. You can follow me on my Instagram profile. These are my pictures of who I am. In the future, I will post Instagram reels and videos where I post videos about American politics and I give my opinion and analysis on current events in American politics. So you can continue to learn from me on my Instagram for free. And then also, this is my Facebook profile. This is what my Facebook profile looks like, my profile picture. This is my page on Facebook. I'll post relevant posts on Facebook about American politics and my life so you can stay connected with me on Facebook. So I have a LinkedIn profile, Instagram profile, and Facebook profile. If you want to ask me questions about my American Politics Masterclass or American Politics online course, then what you can do is you can send me a message on LinkedIn, Instagram, or Facebook and just ask me any question, and when I have the time, I'll respond back to your question with my honest, truthful answer. So you can continue to learn about American politics from me for free. So please follow me on social media. Connect with me on LinkedIn, follow me on Instagram, and add me on Facebook. So you continue to learn about American politics from me for free. So please connect with me on social media. Thanks. Now, I hope you enjoyed my free American Politics Masterclass. If you would like to learn more about American politics from me, I have an amazing offer for you. I created a comprehensive and thorough online course in American politics called American Politics and Government, Understanding the Government Process and Policymakers' Use of Power in Politics in Our Government Institutions. This online course I created is an online course where I teach you the fundamental knowledge and understanding of our government institutions and how policymakers exercise power within those government institutions. My online course is comprehensive and thorough. I give you my all in my online course. The purpose of my online course is to teach you the fundamental knowledge of American politics, government, and history, so that you can become an informed citizen within our society and understand how our government process functions and how policymakers exercise power within those government institutions. The knowledge of American politics is important because without the correct knowledge of American politics, you won't know how to pursue your own political interests within our society. Some of the subject matters that I teach in my online course include the Articles of Confederation, Declaration of Independence, why the Articles of Confederation failed as America's first form of government, the Constitutional Convention of 1787, the U.S. Constitution, the 7 Articles of the U.S. Constitution, separation of powers, checks and balances, the powers of 3 branches of government, how a bill becomes a law in Congress, how members of Congress are pursued by their own political interests in Congress, how the President of the United States exercises power through persuasion and executive orders and signing statements, the express powers of the presidency under Article 2 of the U.S. Constitution. I also go over the U.S. Supreme Court, how the Supreme Court of the United States takes and decides a case, how the Supreme Court decides a case through its procedures, and how they reason and argue cases through their legal arguments and legal opinions on every case that comes before the U.S. Supreme Court. I go over the presidential primary elections, general elections, and primary elections. I go over differences between a caucus and a primary. I go over the importance of how primary leads to the general election, and I go over the electoral college as well. And I also discuss the 2016 presidential election between Donald Trump versus Hillary Clinton. I go over the 2020 presidential election between Donald Trump versus Joe Biden, and I give the thoughtful reasons as to why Donald Trump lost the 2020 presidential election to Joe Biden. And I go over the 2024 presidential election between Donald Trump versus Kamala Harris. And so I go over the main subject matters. I also go over foreign policy and domestic policy. I go over why Vladimir Putin invaded Ukraine. I discuss and explain the Russia-Ukraine war in detail through a 5-part series under American foreign policy in a chapter. And I discuss international organizations like the United Nations and NATO. And I go over all the important subject matters you can think of so that you can have the important knowledge and understanding to become an informed citizen within our society. So those are the various subject matters I go over. There are 14 chapters in my online course, and I go over the subject matters that are very important to become a knowledgeable, informed citizen of our society. At the end of my online course, the transformation I provide to you is that you will become a knowledgeable, informed citizen, and you will have the necessary knowledge to understand our government institutions and how government policymakers exercise power within our government institutions. Not only will you learn that from my online course through 14 chapters of my online course, but also you will have unparalleled access to me to continually learn about American politics from me for as long as you want. When I have enough students, I will create Zoom meetings or Google meetings with my students where I discuss important subject matters from my online course, and I teach and explain important subject matters from my online course to you directly through Zoom meetings or Google meetings. And I go over current events in American politics where I discuss my opinion and my analysis on those current events in American politics. And then I take questions and answers from my students directly, and I answer your questions you have on my online course and current events in American politics as well. And then when I have enough students, I will create a group meeting, a private group meeting where we can all discuss about American politics. You can ask the questions and I answer your questions through a private group meeting on the internet. So you will gain unparalleled access to me to learn about American politics continually. If you would like to purchase my online course on American politics and government, you can scroll down on your screen and press the green button below this video, and you can purchase my online course by pressing the green button below on your screen and purchasing my online course. And then once you purchase my online course, you can continue to learn about American politics from me. If you would like to learn more about American politics and talk to with me over the phone, you can send me an email to my personal email address below. I'll include a copy of my personal email address below. If you want to talk to me over the phone and ask me questions about my online course or what you will learn before you make a decision to purchase my online course, just send me an email below, and then we can set up a date and time for you to talk to me over the phone before you make a decision to purchase my online course. And I'll be more than happy to talk with you over the phone about my online course. So I'll include a copy of my email address below. So that wraps up my online course and my free masterclass in American politics. I hope you enjoyed it. I gave you my all. I gave you the fundamental knowledge you need to learn about American politics, and you can continue to learn about American politics from me by purchasing my online course below. So I hope you enjoyed my free American politics. Connect with me on social media, Facebook, Instagram, LinkedIn, and feel free to send me a message or DM on Facebook, Instagram, and LinkedIn, and I'll respond back to your messages. And so I hope to connect with you in the future, and I hope you will consider purchasing my online course in American politics. This is Kent Tran. Peace. I'm out.